in the Carpe Donktum lawsuit. So this is the question I have for you. I think I know the answer because I think it's obvious. But in the Carpe Donktum lawsuit, for anybody who does not remember this event, the video that went viral of a young black child and a young white child running at each other in open arms in a New York street, and they hug, and the parents put the video online. It goes viral. It gets licensed by a video licensing agency. I'm fairly certain it was Jukin, because I think it was the same licensing agency that had the incident with MXR Plays, who vigorously protect the copyright of their clients. The video went viral, being fully licensed. And then Carpe Donktum, for anybody who doesn't know who he is, he's a meme master, a meme smith, who is making some of the best, most catchy memes in support of Donald Trump, and he's vocal about it. He memed this video where instead of it being a white and a black kid hugging and being beautiful, he played a portion of the video where the white kid was chasing the black kid and then said, "Racist baby, probably Trump supporter chasing a kid, yada, yada, yada. But here's what actually happened." Played the original video and says, "Don't trust fake news. Only you can prevent fake news dumpster fires." As if to show that fake news can literally reverse the meaning of a video with the same content of that video itself. Trump for president retweeted. The parents of these two toddlers sue Carpe Donktum and Trump for president for civil rights violations. I think they ancillary threw in a copyright allegation, but not a copyright claim. And what were the other bases of the lawsuits? Oh, intentional infliction of emotional distress. Anyways, we covered it at the time. I said that I didn't think it was going to go anywhere. I thought it actually took audacity to sue because someone made a variation of a video involving your kids that you willingly posted online and then claimed privacy rights violations under the civil rights law of New York. Anyways, it got tossed, and it got tossed proper, except the judge, to throw one, not to punish the plaintiffs too hard, did not order them to pay the legal, did not grant the cause of action that would have otherwise been given to the prevailing defendants on an anti-SLAPP dismissal to go after the plaintiff for legal fees. And I just said, that this was dismissed partly on civil rights law and partly on anti-SLAPP legislation, where the judge said this is clearly a SLAPP suit invoking the anti-SLAPP legislation. It's dismissed on that basis, and it can create a reverse cause of action where the defendants can go after the plaintiff for their failed lawsuit to recover legal fees. And the judge, I guess, just because he liked them, created some confusion as to whether or not this was a novel issue that could warrant that claim, and did not grant the defendants that claim.
Completely. I mean, that was very rare. I mean, now this is the new New York anti-SLAPP statute. So probably part of his motivation was there's probably going to be pushback by a lot of New York judges on the aggressiveness of the anti-SLAPP law that now exists in New York, because it imposes these really tough penalties and fee shifting provisions that they don't like to enforce. So I think that was probably also in play. He didn't like doing it in this particular case, and he probably doesn't like it in general. He's probably going to be one of those judges, but he's probably going to get overturned if they appeal it, because generally the whole point of their amendment of the law was to make it as almost a matter of right. There's some dispute about that, about whether that was the intention of but in most states, the anti-SLAPP law makes it almost a matter of right that you get your legal fees when you win. And this was everybody knew this was contrary to what the judge said, saying there was some good faith basis of extension of law because it had a campaign connection. That was nonsense.
The plaintiffs alleged that this was for commercial or advertising purposes, and the judge says no, it's clearly not. It wasn't.
It's a meme.
But then says, the reversal of this presumption where the defendant can claim legal fees from the plaintiff is unless there was some novel question of law that the plaintiffs raised in the lawsuit, such that there's an exception to the otherwise, like you say, basic codified automatic rule that if a plaintiff sues and it gets dismissed on anti-SLAPP, they pay the legal fees. That's the way it works, because you basically try to suppress someone's First Amendment rights through a strategic lawsuit against public participation. And the judge just, I think it's out of whole cloth, fabricates a novel question, because I didn't see it. But I was sitting there saying, okay, well, can the defendants appeal? But what are the chances that the defendants appeal the dismissal of the plaintiff's lawsuit? Because in theory, even if they appeal, could not a court of appeal say, we're reinstating the lawsuit, we don't think it should have been dismissed in the first place?
I mean, that's always possible, but and presumably the other side, but they could just appeal the attorney's fees order. They could appeal just the denial of the attorney's fees, and then it'd be on the other side whether they want to challenge that by also appealing the judge's order. But they're not going to win that. I mean, that was open and shut. That was to claim a meme is somebody stealing your image for corporate advertising purposes was a preposterous claim.
Especially, look, I presume the law is relatively the same, but stealing your images for corporate profit typically is when you didn't sign up for any publicity in the first place, when you didn't put you still cannot commercialize someone's image, even if they put the video online intentionally. So a classic example is that, we've talked about it, but the German guy, oh God, the Techno Viking, someone else commercialized this guy's face on mugs and made money on it. And he was ordered to give it back. It was under German law, but I suspect it's roughly the same as even if you put a video out there, you can't take that kid's picture, put it on mugs and market it and sell it. But this is a case where they put the video out there. It went viral. They were doing the rounds of interviews. These people were not selling shirts with the kids hugging on it. It was a meme for Twitter. And so there was this was cut and dry. But Robert, I know I take flack for this sometimes, but I come from the perspective.
I would say they probably made more money at the end of the day too. Like if this was a damages case, if Carpe Donktum had never done what he did, probably fewer people would have seen his licensed image because it led them to the licensed image. It popularized that image in general. So they made more money off of this, not less.
Well, the argument that I thought should have been made, which they didn't, is just go for a straight copyright claim. Because we all know the rules, fair use, transformation, parody, etc. But when the Carpe Donktum's meme used the entire original video to show what actually happened. And in my mind, if you want to make a claim, that would have been the strongest claim. It's pure copyright infringement because the modified version of the meme or the modified version of the video through the meme, if it doesn't replay the original video in its entirety, people are still going to have to go see the original video. Whereas what Carpe Donktum did was he made his modified version and then showed the original in its entirety. So that's where I would have gone, but they didn't go there. I don't know that they can go there now, but it got dismissed as it should have, cut and dry, clear cut. I mean, the judge was unforgiving in the reasons for which it was dismissed, but then he was very forgiving and just to let them off of the legal fees claim, which I think is problematic because that's what the anti-SLAPP legislation was there for in the first place.
Yep. So it'll be up to, I don't know if Carpe wants to really fight it up on the legal fees aspect because that's still in the process of being developed in New York under New York law. But if he does, I think he has an above average chance, but still a great win in court to protect his right to, even in a New York state court, where usually the odds are stacked against you if you're on the right, political right side of the aisle. The court recognized that the law completely protected him and dismissed the entire nonsense. So still a great win for him, a great win for Ron Coleman, who was his lawyer in the matter. He's now partners with Harmeet Dillon, the kind of people Trump should have consulted before he filed his suit. But but great win for him, and congratulations to him and Carpe.
And now, speaking of New York courts getting something right, let me just see this. Isn't it premature to be seeking sanctions, et cetera, of Sidney Powell while issues are still ongoing in Michigan?
One, that suit they lost. That's the federal suit that they lost. There's no pending litigation that Sidney Powell's a part of in Michigan that's subject to that sanctions motion. The issues in Michigan, I'll be honest, I get Mike Lindell still doing his thing. I see Patrick Burns still doing his thing. Usually when I investigate, their facts come out wrong repeatedly. So, I mean, I still think the better focus is where Arizona's doing it, where some people in Georgia are doing it, where people in Pennsylvania are doing it. Look at signatures, look at whether the ballots were properly counted and so forth, rather than, again, Richard Barris and I looked at this. The computers and the machines had nothing to do with this election outcome. It just didn't. The evidence proved that from the day one.
I got to bring this up because I did forget. Yeah, 63 Rambler. Wasn't the case about subtext? We are traumatized by our children being used for the wrong political message. Boo. Literally, they alleged intentional infliction of emotional distress, which has a 4-pronged test, which is excessively difficult to make. This wasn't. I can imagine someone making a video using those kids' images in a way that would be intentional infliction of emotional distress. To allege that this is much akin to that reporter talking about January 6th and saying that was the trauma that led him to, have life-altering issues. But no, speaking of New York courts getting it right again, Project Veritas.